The account already shows charged off on the credit report. As far as most people understand it, that should mean it's over, written off, done, in the past. And then the phone rings. A collector asking for payment on a debt that already shows as charged off. This confuses people constantly, and the confusion itself is often exploited by aggressive or poorly informed collectors. Tonight, what a charge-off actually means, why the calls continue anyway, and the specific legal rights available at this exact stage that most people being contacted have no idea they have. A charge-off is an accounting classification, not a legal forgiveness of debt. When an account goes unpaid for an extended period, generally around 6 months of non-payment, the original creditor formally reclassifies it on their own books as a loss for their internal accounting and tax purposes. This is the critical misunderstanding. Charge-off describes what the original creditor did on their financial statements. It does not mean the debt has been forgiven, canceled, or that collection has ended. The debt is still legally owed, and the original creditor, or whoever the debt gets sold or assigned to afterward, generally still has the legal right to pursue collection, exactly as before the charge-off classification was applied. The word charged off simply doesn't carry the finality that it sounds like it should. It's a bookkeeping term that happened to also become the source of enormous public confusion. After a charge-off, a debt typically follows one of a few paths, and understanding which one applies changes what's actually happening on the other end of those calls. The original creditor may continue attempting collection internally for a period after the charge-off, even though it's now classified as a loss on their books. Alternatively, the original creditor may assign or sell the debt to a third-party collection agency, which then owns or has been granted rights to collect on that specific debt. In either case, the calls and letters continue because the underlying legal obligation to pay hasn't gone anywhere. Only the original creditor's internal accounting treatment changed. Whoever is now attempting to collect, whether the original creditor's internal collections department or a purchased debt agency, has a legitimate legal basis to continue pursuing payment within the boundaries of what's about to be covered. This is where the actual protections come in, and they're substantial, even though a charge-off itself doesn't stop collection. The right to debt validation, covered in an earlier video, applies here exactly as it does to any collection contact. A written request for validation, sent within the appropriate window after first contact from whoever is currently attempting to collect, requires them to prove the debt is accurate, the amount is correct, and they have the legal right to collect it. The right to request that contact stop or be limited. Federal consumer protection law generally provides the right to request that a collector cease contact or restrict how and when contact happens through a written request. This doesn't eliminate the debt, but it can stop the calls specifically, forcing communication into writing only, which many people find genuinely relieves the harassment feeling, even while the underlying debt situation still needs to be addressed. The right to protection from abusive or deceptive practices. Threats of legal action that aren't actually being pursued, misrepresenting the amount owed, contacting at unreasonable hours, contacting employers or family members inappropriately. These practices are generally prohibited, and violations can potentially be reported or even provide grounds for legal action against the collector. The right to know exactly who is calling and on whose behalf. collectors are generally required to identify themselves clearly and disclose that the communication is an attempt to collect a debt. Vague or evasive identification is itself a red flag worth documenting. As covered in an earlier video on collections, the statute of limitations on legal action for a debt doesn't reset simply because it's been charged off, and this remains one of the most important pieces of leverage available at this stage. Every state has a time limit on how long a creditor or collector can sue over a debt, and once that window passes, the debt becomes what's generally called time-barred. It can still legally be reported on a credit file for up to 7 years from the original delinquency date, and collectors can, in some circumstances, still attempt to collect through calls and letters, even after the statute has expired. But they generally cannot successfully sue for it once that legal window has closed. This is precisely why confirming the original delinquency date and calculating the applicable statute of limitations before making any payment or acknowledgement remains critical even at the charged-off stage. Making a payment, or in some states even a verbal acknowledgement of the debt, can potentially restart that clock in certain jurisdictions, converting a time-barred debt back into one that's legally actionable again. Bringing this together into the actual sequence for someone currently being contacted about a charged-off account. Don't make a payment or verbally acknowledge the debt on the phone before understanding the full picture. This protects against accidentally restarting a statute of limitations clock on a debt that might already be time-barred. Request validation in writing, confirming this is the correct debt, the correct amount, and that whoever is contacting has the legal right to collect it. Calculate the statute of limitations based on the original delinquency date, not the charge-off date, since these are sometimes different, and the delinquency date is what generally starts that legal clock. If the harassment itself is the primary issue, send a written request to limit or cease contact. Understanding this addresses the calls specifically without resolving the underlying debt. Once the full picture is clear, validated or not, time-barred or not, make an informed decision. Dispute if something doesn't check out. Negotiate a settlement if the debt is legitimate and within the collection window, or simply allow it to continue aging toward the 7-year reporting limit if that's the more sensible path for the specific situation. Charge-off sounds like an ending, but it's really just an accounting reclassification on the original creditor's books, and the debt itself remains fully collectible, with the calls and letters continuing well past that point exactly as before. The protections available at this stage are real and substantial. Validation rights, the right to limit or stop contact, protection from abusive collection practices, and critically, a statute of limitations that continues running from the original delinquency date. Regardless of the charge-off classification, that determines whether the debt can still legally be pursued in court. The confusion around what charged off actually means is exactly what gets exploited by aggressive collection tactics. Understanding the real mechanics is what stops that from working. This is Credit Clarity. We'll see you in the next one.